Should a prisoner be forced to participate in religious activities in order to be eligible for parole? A federal judge recently issued a preliminary injunction saying, absolutely not. In regular speak, that means the good guys won. For now, let me explain. Back in April, American Atheist filed a federal lawsuit on behalf of their client, Andrew T. Miller, against the West Virginia Division of Corrections and Rehabilitation, the prison. What was the problem? Well, Miller entered prison in 2021 after being convicted of breaking and entering, and he's currently serving a sentence of 1 to 10 years with a projected release date of April 3rd, 2025. He committed a crime. He was found guilty. He is facing the consequences. Fine, but being seen as a good inmate has a direct impact on how soon he'll regain his freedom. If he behaves behind bars, he could get out before 2025. One other thing you need to know about Miller is that he struggles with substance abuse. But he's fine with going through a treatment program to resolve that. So, according to the lawsuit, the prison operates a program called Residential Substance Abuse Treatment, RSAT, and inmates who are placed in that program are required to complete it if they want to be granted parole. Not going through the 6 to 12 month program basically deems you more of a security threat. In other words, if you struggle with substance abuse, and you want to get out of prison, you need to complete that treatment program. That, American Atheist claimed, is a problem because the RSAT handbook is chock full of Christianity. It includes the Lord's Prayer and the Serenity Prayer and the infamous 12 steps, all of which reference a higher power at minimum. Another part of the handbook tells participants, for our group purpose, there is but one ultimate authority, a loving God as he may express himself in our group conscience. Our leaders are but trusted servants. They do not govern. It's not just items in the book. Some of the required homework involves telling the course leader what God means to me and what prayer means to me. So soon after Miller was incarcerated, he was told he had to go through the RSAT program. He quickly realized how religious it was, though, and asked for an alternative option. And those options do exist. I mean, several of them. Miller was willing to do everything in the course that didn't involve professing a religious faith he didn't have. And the lawsuit says he actually made that request in July of 2021. Unfortunately, his request was denied. So were his multiple grievance complaints challenging that denial. The people in charge said he had no choice but to go through the Christian program. As a result of this pushback, he was denied parole 3 separate times, with the board specifically citing the non-completion of the religious RSAT program as a significant reason he was not allowed to go free. That's why American Atheist took up this case. As their attorney wrote, West Virginia should not be forcing Christianity on the people incarcerated in their facilities as a condition of release. This was not a complicated request on Miller's end. He wasn't arguing against going through a substance abuse treatment program. He just didn't want someone else's religion shoved in his face in the process. Just as a Christian inmate shouldn't have to adopt Islam in order to get out of prison sooner, or vice versa, an atheist inmate shouldn't have to pretend to be religious for the parole board to deem him worthy of freedom. The irony is that if he just lied about his beliefs, there's a chance he could have gotten out sooner. It's the people running the prison who insisted that he mislead everyone in order to convince them of his goodness. I mean, how does that make any sense? Miller tried multiple times to fix this on his own. He got nowhere. This lawsuit was the last resort. It said the prison violated the Religious Land Use and Institutionalized Persons Act, or RLUIPA, and the Establishment, Free Exercise, and Free Speech clauses of the Constitution. In response, the prison said that all those controversial elements of the program were merely spiritual in nature, not religious, and certainly not Christian. That argument, thankfully, failed. Recently, a U.S. district judge issued a preliminary injunction in the matter, telling the prison to remove the RSAT program from Miller's individual re-entry program plan, and see to it that participation in the RSAT program is not considered as a factor in his eligibility for parole. The judge didn't say to set him free, but rather the prison couldn't use the Christian program as a factor in whether or not he got released. It was a powerful ruling in favor of Miller and the atheists. This judge explained that plenty of other states with similar programs have faced lawsuits, and the courts have unanimously agreed that the religious content of those programs violated the Constitution. The RSAT program, he said, was no less religious or coercive than the ones that have already been struck down. In other words, this was not a complicated decision. He had no choice but to do this. Why a preliminary injunction and not, say, a permanent one? Part of the answer is that if action isn't taken immediately, Miller, the judge said, would be likely to suffer irreparable harm. That's because, as the judge explained, even if Miller began a secular treatment program right now, he wouldn't have enough time to complete it before his next date in front of the parole board. And there's a good chance he would be free right now if not for the religious RSAT program. But check out some of what the judge said. Throughout this ruling, there were blunt statements slamming the prison for forcing Miller to go through their religious program. The factual allegations contained in the complaint, if true, show that the state of West Virginia has coerced plaintiff into religious exercise. In sum, the evidence before the court wholly supports Mr. Miller's allegations that the defendants have substantially burdened his protected religious exercise. Having found that the state's objective does not justify the challenged program, I conclude that plaintiff is likely to succeed on the merits of his Arlupa claim. Because Mr. Miller has shown an unreasonable encroachment on his First Amendment rights, I find him likely to succeed on the merits of his free exercise claim. Because Mr. Miller has shown a clear likelihood of a constitutional violation, he has shown irreparable harm. Who knew that there were so many different ways to tell prison officials they're the ones breaking the law? There were ultimately a couple of options suggested by Miller's lawyers. He could complete a secular treatment program, which is what he always offered to do. Or the parole board could just ignore the religious RSAT program when considering his possible release. To prevent this from dragging on, the judge agreed with that latter suggestion. Had Mr. Miller simply submitted to defendants' coercion and completed RSAT, he likely would no longer be incarcerated, and the prison could continue its patently impermissible practices for years to come. Mr. Miller should not be further punished for bringing this troubling policy to light. The 59-page ruling is just a massive public rebuttal to everything the prison was doing, and they deserve every bit of it. No one should have to abandon their religious or non-religious beliefs in order to be let out of prison. No one should be forced by the government to profess a belief in the spiritual or supernatural. In this case, it was the prison taking the unethical approach. The next step is for the prison to change its policies entirely. I don't have any opinion on whether or not Miller should be released early. That's not for me to decide. But conditioning his release on his acceptance of Christianity, that is just plain wrong.